Hi, I'm Anna Denton-Jones of Refreshing Law, and as part of Knowledge November this week, we are looking at employees' failure to attend disciplinary hearing due to ill health. Quite often, employees become very stressed and their GP will sign them off as such during this period. So, what does the employer do in that situation? Now, the ACAS code starts from the perspective of assuming that everybody is going to attempt to hold a disciplinary hearing without what they call an avoidable delay. So our starting point is obviously that we want to get on with things. The reason why we want to do that is we wouldn't want something hanging over somebody for longer than it needs to. But when somebody is unwell and they can't attend for that reason, we're not simply as employers entitled to go ahead and have a disciplinary hearing in somebody's absence. We are expected to wait for them to be well enough to attend. Now, what is reasonable in any given case is going to obviously depend on the particular facts of the case. So ACAS talk about looking at the following list of things. So they will look at what rules have already been put in place around disciplinary hearings. And one of the things that I am now doing when I'm writing sickness policies is putting a little bit more in them around what if I am ill when I'm subject to a disciplinary process, to try and manage people's expectations around that. Obviously, the particular seriousness of a disciplinary allegation will be a factor in any particular situation. Somebody's record, if they've been a long-serving employee with a hitherto clean record, you are going to be expected as an employer to wait and try and rearrange the hearing, for example, before you would ever go ahead and have a hearing without the person being there. Medical opinion can be really useful. Certainly one of the things that I often do is write to GPs or get people assessed by occupational health to understand whether or not they're fit to come to a disciplinary hearing, because obviously there's a big difference between being signed off from work in general and not being fit to do your whole job versus whether or not you're fit to attend a meeting. And sometimes you can get a medic to agree that actually it would be helpful for somebody to sort of face the music and be able to deal with that. They will also look at how previous cases have been dealt with. So if you have waited in the past, then you might be seen as unreasonable if you've rushed ahead now. And one of the things I quite often remind employers is whilst we're in the middle of these situations, it can seem quite urgent, and that we've got good reasons why we want to get on with the process and we want to be able to move on or know where we are. But when we're in tribunal fighting about it in a year's time, all of a sudden the 3-4 months perhaps that we've waited for something doesn't seem like quite as much a longer period now. So we need to bear in mind, how is this going to look in the future? Is it going to look like we've rushed? And certainly I've seen a case recently published where an employer was seen to be really pressurising somebody to get to a hearing, and that didn't go in the employer's favour. If you are obtaining medical advice, be very careful. I've had a situation recently where we were getting advice from occupational health, and occupational health told us that the employee was just temporarily unwell and would be able to attend a disciplinary process fairly shortly. That occupational health provider did not make contact with the employee's GP and discover that there was actually a disability lurking in the background in terms of that person's level of anxiety and depression. So that sort of came back to bite us a little bit later in the process. So make sure, if you are instructing occupational health, that you do ask them to make contact with the GP and get the full picture, and that they have done that when they speak to you. Otherwise, they might give you quite a misleading view of things. So it's important to check that out. Generally, therefore, we're going to accommodate somebody's request for a postponement on ill health grounds. If anything, the delay is only going to make you look like a reasonable employer who's waited. If you rush and you try and go ahead without the employee's cooperation, then there's a potential that that backfires against you in employment tribunal at a later stage. Obviously, if we've rearranged a number of times and this has gone on for a very long period, we might reach a point at which we start to say to somebody, let's look at alternatives. Can you send your representative along instead of you, your companion instead of you? Can you make written representations instead? We want to do everything that we could to make sure that individual had the opportunity of having their say at the disciplinary before we went ahead in their absence because of ill health. Certainly if there's a disability and there is depression or something lurking in the background, then we'll be expected to make reasonable adjustments, and a reasonable adjustment would be to delay the process. I know that can be frustrating for employers because they feel like they're paying somebody where they feel strong evidence that that person has committed gross misconduct, for example. But it's a trade-off between saving a little bit of money now and potentially that risk in a tribunal later. So it is sensible to take advice on a given situation before you do anything rash. If anyone does need any help with these sorts of issues, do give me a call, 02920 599 993. Thanks.